Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and this is another episode of Ask the Lawyer. Today, we're going to ask the lawyer about something that a lot of us are not exactly comfortable talking about: end-of-life planning, specifically wills and trusts. And here to help us today is attorney Marty Fogerty of the Heartland Law Firm in Glenview, Illinois. He's an advocate for elders, handles cases involving estate planning and elder law. And he's been nice enough to make some time for us here today to answer our questions. Marty, thank you for helping us out today.
Pleasure to be here. Thank you.
So let's start with the very basics. Let's start off with just a couple of quick definitions. What is a will as it applies in the law?
So a will, the way to look at a will, it's instructions on what should happen to your stuff, who should own your stuff when you pass away. It's a letter to the probate court, because the way to look at this is, when you're alive, you control your stuff. When you die, there's a question: who controls it? Well, your will is a letter. It says, "Dear Judge, I'm Marty Fogarty. Here's what I want to have happen to the stuff that I own." And then that judge oversees the administration of your estate so that what you wanted to go to who happens.
Right. And without a will, who decides? Heirs, and without heirs, then what?
Yeah. So if you don't have a will, then the state has already written a plan for you. And it basically says, again, you have to go to probate, and the probate court and judge says, well, did Marty leave us a letter telling us what he wanted? Did he leave us a will? No, he didn't. Okay, we're going to apply the probate statute, which will say, well, was Marty married? Did he have kids? Are his parents alive? And there's a whole structure that they have to follow. But it's a very expensive and long process, and just easily avoided. And in today's world, we're not really interested in having a third party decide where our stuff goes. Or I really don't want to have a judge to have to give me permission to give my stuff to my kids if I pass away. I feel like I should be able to do that on my own.
All right, so that's a will. Now we hear about trust. What is a trust, and how is it the same or different from a will?
Yeah. So think about this. The trust is like the antidote for that problem of having to get the court's permission to give your stuff to your kids or your loved one. A trust is an entity that you create, sort of like a company. Like if you create a company, I've created my law firm, and my law firm owns my pens and my pencils and the desks. Well, my trust owns my house, and my trust owns my bank accounts. What that means is, at the bank, I say, I'd like to transfer ownership of this account from my name as Marty individually to Marty as trustee of his trust. Now the trust, think of it like a bucket, and it owns things, and it's got a series of instructions. And the instructions basically say, when Marty is alive and well, he's in charge. He gets to do whatever he wants with this money, with these assets, they're his. But if he's incapacitated, then he gets to name who should be in charge for him. And when he passes away, he gets to say, hey, when I die, here's where my stuff should go. And the difference between the will and the trust is that with a will, we have to go to a third party, to probate court, and we have to get their approval and permission to transfer my assets to whoever I name. But with a trust, I don't need to go through that public process. I can name my own trustee, and their job is to follow the instructions I put in my trust so that my assets can go to the people or places that I've named.
And naming a trustee, can you pick anybody to be your trustee? Are there rules about who can be a trustee?
Yeah, great question. So the question best framed is, if you couldn't sign your name, if you needed someone reliable to follow your instructions and honor your wishes, if you couldn't make them happen, who are those people? And usually it's a spouse or a brother or a child or a sister, someone very trustworthy from your tight nuclear family. Now, there are corporate trustees. Banks are commonly, in the past, historically have been named as trustees. But unless there are some complexities in your circumstances, what I find with most families is that they are choosing a loved one, a trusted loved one, to be their backup trustee, their first successor or second successor trustee, or even co-trustees.
Is it always beneficial to someone to have a trust rather than a will? Are there some cases where a will is good enough? How do you pick?
Yeah, great question. So the thing here is, life is, we don't have a crystal ball. So if I'm going to live my life and then pass away, and I'm not going to have a period of time where I'm incapacitated, perhaps, or maybe I'm suffering through a period of dementia or that sort of thing, then a will can work pretty well, because I can, if I'm basically taking what I own and I'm naming the owner of all my accounts to be someone else. So in other words, I name a beneficiary for everything I own. Then when I pass away, everything would automatically go to that person outside of probate. But the reality is that life is complex, and we don't go from alive and well to passing away. A lot of times we go through this alive and not so well stage. And it's not a black or white issue. There's some shades of gray in there. And having a trust own your property and having one person in charge of being able to take the helm if you can't manage your assets or manage your funds, or make a decision, let's sell the house and then move you to a more appropriate living situation. All that complexity works much better with a trust. So what we have kind of a rule of thumb: if you own real estate, if you've got kids, you're usually solving this from a position of, let's just go the trust route because of the great peace of mind you get. Once you set this trust up, you're pretty well set. You don't have to make a lot of changes in your life or in your estate plan once you get the trust set up.
Now, what is a living trust? Is that the same thing? How does that figure in?
Yeah. So you'll hear these terms: living trust, revocable living trust, asset protection trust, special needs trust. They're just, the trust exists to solve a problem, right? So if it's the trust that 95% of the people have out there is called a revocable living trust or a living trust. Now, a living trust is just a trust that I made when I'm alive. That's opposed to a testamentary trust, a trust that comes into being after I'm gone.
And so I think I know the answer to this question, but when should people start thinking about and making these end-of-life decisions? Is there ever a time when it's too early? Is there a time when it's too late? What's your suggestion?
Yeah, I think that life gives us this a series of chapters, right? And when we turn 18, we've become adults. We don't own a whole lot probably, but we're adults. So at that time, you don't need a will or a trust. You need powers of attorney. But let's say as you get further on in life and you start to own things and you start to become in relationships with people, or you start to have kids, certainly once you're into that realm, that's time to do your planning. It's time to, identify what are the legal questions that I can solve right now that are going to act as guardrails if a mess happens.
And I would assume it's important as you go through life and there's certain milestones and life changes, that sort of thing. It's important to update your will and or trust to coincide with that?
Yeah. So basically, I describe our relationship with families that you're on life's road. It's going to go twist and turn, and our job is to be there for you as guardrails. We're going to check in on a fairly regular basis, but we're not going to get in your way. There's an appropriate orbit there that we should keep with each other. But your relationship is the real value of your estate plan. It's not a piece of paper. Don't solve so it's a piece of paper. Solve so that you have a relationship with a lawyer backed by a team. So you need a law firm that has great processes that help make the choices you've got to make, that they make that really easy for you and understandable, and that they've got a system that they follow so that you know when you'll be hearing from them, that you're not feeling like you're getting charged every time you call with a question and that sort of a thing. Estate planning is a relationship more than a document. That's an important piece for your listeners to know.
I really like that guardrail metaphor. That's good. I like that.
Mm-hmm.
I think you've helped a lot of people today, Marty. Thank you so much for your time. I appreciate it. And we'll talk some more in the future.
Okay, thanks so much.
There you go.
Bye.
That's going to do it for this episode of Ask the Lawyer. My guest has been Marty Fogerty of the Heartland Law Firm in Glenview, Illinois. Please take a second to subscribe to our YouTube channel by clicking on the button at the bottom of the screen, and that way you'll know about future episodes. And if you need the best information about wills and trusts, you're ready to choose a lawyer that lawyers choose, be sure to visit AskTheLawyers.com. I'm Rob Rosenthal for AskTheLawyers.com.